Can a landlord run a background check with credit on a tenant without their permission? It's one of the most common questions we get, and the short answer is no. But the full answer involves some important legal details that every landlord and property manager needs to understand. The primary law governing tenant background checks is the Fair Credit Reporting Act, known as the FCRA. This is a federal law that applies in all 50 states, and it sets clear rules about when and how consumer reports, which include background checks with credit reports, can be obtained and used. Under the FCRA, a landlord must have what's called a permissible purpose to request a consumer report. Evaluating a rental application is a recognized permissible purpose, but, and this is critical, the landlord must also obtain the applicant's written consent before pulling the report. This consent must be clear and conspicuous, and it should be documented separately or prominently within the rental application. If you run a background check that includes credit without the applicant's written consent, you are violating the FCRA. The consequences are serious. Tenants can sue for actual damages, and in cases of willful noncompliance, they can recover statutory damages of $100 to $1,000 per violation, plus attorney's fees. Class action lawsuits under the FCRA have resulted in multi-million-dollar settlements against landlords and property management companies who failed to follow proper procedures. Beyond obtaining consent, the FCRA also requires landlords to follow the adverse action process if they deny a rental application based in whole or in part on information found in the background check. This means you must provide the applicant with a pre-adverse action notice that includes a copy of the report and a summary of their rights. You must then give them a reasonable time to dispute any inaccuracies before making a final decision. And if you proceed with the denial, you must send a formal adverse action notice identifying the screening company that provided the report. Now, here's where it gets even more nuanced. Many states have their own laws that add additional requirements on top of the FCRA. Some states limit what information landlords can consider in a background check. For example, several states and cities have adopted ban-the-box laws that restrict or prohibit landlords from considering criminal history in rental decisions. Other jurisdictions limit how far back a landlord can look into an applicant's criminal record. And some states require additional disclosures or impose stricter consent requirements beyond what the FCRA mandates. California, New York, Illinois, Washington, Oregon, and New Jersey are among the states with additional screening restrictions. And cities like Seattle, San Francisco, Portland, Minneapolis, and Newark have their own local ordinances that further regulate tenant screening. If you manage properties in multiple states or cities, you need to be aware of each jurisdiction's specific rules. There's also the question of screening fees. Many states regulate whether landlords can charge applicants for background checks, and if so, how much. Some states cap the screening fee at a specific dollar amount. Others require the landlord to provide a receipt or itemized breakdown. Charging excessive fees or failing to follow state-specific fee regulations can create additional legal exposure. The bottom line is this: always get written consent before running a background check on a prospective tenant. Follow the FCRA requirements for adverse action if you deny the application. And know the specific laws in your state and city that may impose additional restrictions. Running background checks the right way protects you legally and helps you find reliable tenants. At tenantscreeningbackgroundcheck.com, we make the process simple, fast, and fully compliant. Visit our site to run your next screening and subscribe to this channel for more landlord tips and legal guides.